Good morning, good afternoon. Welcome to this webinar. My name is Axel Frazzini, and I will be your host today. Housekeeping reminders. This webinar will start in approximately 20 seconds. Today's webinar is being recorded, and you will be able to share your questions during the presentation. The recording will be shared later today and tomorrow. So do not hesitate to use the Q&A box that you can see on your screen. So again, welcome everyone to the 4IP Council's webinar on recommendations for the European Commission new framework for standard essential patents. My name is Axel Frazzini. I am the Managing Director of 4IP Council, and I'm your host today. As you may know, 4IP Council is a not-for-profit organization, and we do research on IP and innovation. To identify the most relevant topics and produce empirical research, we work closely with a wide variety of academics, experts, IP organizations, and stakeholders. On our website, you can find a range of free materials, studies, guidelines, summaries of relevant papers, and recordings of our webinars like the one today. Moreover, we produce easy to digest content, specially tailored for non-IP experts, SMEs, and startups. This is free of charge, and some examples of interactive graphics and interviews to inspire SMEs, individuals, and startups are available. With this, we aim to assist innovative startups and SMEs to learn how to use IP to grow their business. As you know, more and more things are increasingly connected thanks to the Internet of Things. To achieve this, standardized technologies are needed, often protected by patents. This is why we have created a case law area with summaries of court cases regarding standard essential patents. This section is also available now in Chinese and Japanese. Without further delay, please allow me to introduce our great speakers, Dr. Bowman Heiden and Dr. Justus Baron. Dr. Bowman Heiden is the co-director of the Center for Intellectual Property, which is a joint center for knowledge-based business development between the University of Gothenburg, Chalmers University of Technology, and the Norwegian University for Science and Technology. Dr. Justus Baron is a senior research associate with the Center on Law, Business, and Economics at Northwestern University, Pritzker School of Law. His area of expertise is the empirical economic analysis of technological innovation and markets for technologies, with a particular focus on technology standards and standards essential patents. Dr. Bowman Heiden and Dr. Justus Baron are both former members of the European Commission Expert Group on Standards Essential Patents. A final remark for the audience: please do not hesitate to use the Q&A tool to submit your live questions during this presentation. You can find the Q&A box at the lower part of the screen. You can raise questions anytime during and after the presentation, and we will take the questions at the end of the presentation. Without further ado, Bowman, the floor is yours.
All right. See if I can move things around a bit here. Great. Perfect. Okay, great. You hear me all right, Axel?
Perfect.
Perfect. All right, great. So thanks so much, Axel, and for 4IP for giving Justus and I opportunity to talk about our paper today and our reasoning. Just as an introduction, our paper, which you all have had access to, I believe, is focused on a policy governance framework for SEP licensing from a private and public ordering perspective. So we're not talking about outputs from the European Commission or from our European Commission expert group, but where we wrote a paper based on our experience in researching in this field for many years, and also from the challenges that we came across in discussing this with many different actors and also in the expert group on how to approach the question of analyzing markets that are enabled by standard essential patents. What is the governance mechanism that's taking place? What is being handled by private actors? Where should the public actors step in? How should policy actors respond to certain situations? So our focus is not on individual outcomes. Our focus is on the methodology for understanding what is the problem, if there is one, what potential solutions are there, and what would be their impact, and how should we roll out these types of solutions in order to have them be implemented in a way that maximizes social welfare. So instead of focusing on specific issues, we thought it would be good and useful for policymakers to have a better toolkit for thinking about how to do the analysis in the first place, what methodology to apply, what framework to apply to understanding these issues. So in order to start with that, we need a little bit of a theoretical framework. So let's start by talking about market governance from a private versus public ordering perspective. And the first thing that comes about from this discussion is that all markets are built on both. So even people who talk about a free market or laissez-faire based economy, even your staunchest libertarian is going to accept the fact that complex markets, especially, but all markets in general, are built on a kind of foundational layer of public ordering. This is where the government steps in and sets up property rights, it enforces contracts, it manages monetary systems and other fundamental building blocks from which markets can be built upon. But on the next layer, which we'll focus mostly on, and we focus on our paper and our talk today, is on the transactional layer. So on the layer of the market that most people talk about as the market, where there's market competition through private ordering, private actors interfacing with one another. And what is there the role of public ordering? How much market regulation, so regulation by the administrative state, how much activity from public actors should be applied on this transactional layer in collaboration or in connection with private ordering. This is one of the key areas that we wanted to look at. And of course, this is one of the key overall questions that people are looking to answer. Where should we let the markets handle things themselves, and where should we have support from government organizations and policymakers? So move the next slide here, great. So in order to look at, so when we talk about public and private ordering, it's not enough really to just put it in those two categories. It's a bit more complicated than that. So first of all, when it comes to public ordering, you can have direct regulation that define the rules of the game. So the administrative state defines specific rules under which market actors can operate. But they also provide a lot of guidance in the form of white papers and research documents and speeches and other types of modes of nudging markets in certain directions related to certain policy objectives that are not as formal as regulations. When it comes to private ordering, it's not only a bunch of individual companies interfacing with each other at arm's length in this based on price mechanisms. There's a lot of collective activity done by private actors as well. So it's good to see that there's a range of different type of private ordering and public ordering mechanisms to choose from, and the way that markets are governed through these different mechanisms and through this spectrum of different opportunities is important to understand before enacting further governance mechanisms. So as an example of collective action within the context of SEPs, we have the idea that standard essential patent enabled markets, such as cellular markets, are no longer, as they were in the very beginning, governed by individual firms producing their own standards to specific markets. These actors have evolved over time to include efforts within an open consensus-based standard development organizations. So we're moving from this kind of market-based competition to a standard-based consensus organization where firms compete on the technology market to get their technology included in the standard, but then one global standard is created towards a global market. So it's important to understand as a beginning, from the beginning, that SEP ecosystem has evolved to include a large degree of collective private ordering to already begin, and that has a major impact already on how markets operate and on further subsequent policy interventions. Also, when it comes to market governance, there's not only direct interactions between public and private actors, as we discussed, there's also indirect interactions. So while policymakers might have direct regulations and market actors might have direct relationships between each other in the market, there's also market actors trying to influence policy actors, which we call regulatory capture. There's also policymakers trying to influence market actors, as we discussed about briefly before, which we call market capture. You could see this quite clearly in a couple of examples that we gave in our paper about ETSI or IEEE, where policymakers go out and give statements that then kind of nudge or give guidance to market actors to then enact certain privately ordered policies on the market, but this comes from a kind of indirect nudging from policymakers and vice versa. Also, we can see that a lot of institutional mechanisms and concepts are created that have indirect influence on market actors and policy actors. Terms such as patent thickets, royalty stacking, patent holdup, patent holdout, all these different concepts and theories that are created also operate to capture people into certain beliefs and tend to make it difficult for a kind of first order analysis of situations as they gain steam from both sides, whether it be public or private actors. So it's extremely important to understand that not only is there direct and a spectrum of direct influences between market actors and policymakers, there's a lot of indirect interactions, and sometimes these indirect interactions can be greater than the direct interactions, which is why you can never really look at things outside of the concept of political economy. So when it comes to this institutional capture, as we talk about, one way to explain that a little bit is how we frame the problem. So when we look at this image here, I know you can't see it very well, but it's basically a description or diagram of what's called the smartphone wars, showing all the different litigations and conflicts that were going on. But we could also, at the same time that this situation was showing a lot of conflicts and difficulty in the market, we also had an exponential growth in cellular subscriptions, where in 2016 we crossed the line where we had more cellular subscriptions than we had people on the planet. So this begs the question, how should we frame the problem? If we come into a governance situation and frame the problem of how do we solve this market failure versus how do we improve on this market success, we will likely have two different outcomes just on the way that we frame this. And since it's not obvious exactly what the problem is and how and to what extent the problem is based on the output, I think the way that this is framed can create a completely different outcome in how policy considerations are done. So this is a critical reframing process, is critical to setting up the problem in the first place. So as we move forward, then we defined a simple assessment framework. We have it a little bit more detailed or rather more detailed in the article. But we want to look at three things, basically. We want to look at defining the problems. We want to look at evaluating solutions. And then, of course, we want to look at implementing solutions, what we call experimental governance. So we ask very simple questions. Is there evidence of a significant problem in the market that cannot be managed through private ordering? When it comes to solutions, will public ordering solution increase social welfare or decrease? What will be the impact of the solution? And given the complexity and uncertainty of the outcome, how can we test the impact of potential solutions and adjust in a meaningful and expeditious way? So just with these basic questions as a framework, we then dig into a lot of the complexity. And now Justus will take over from here to look into how you would go about looking at these issues from an SEP perspective to be able to answer these relatively simple but complex questions. Justus.
Yeah, thank you very much, Bo. And also from my side, thank you very much to the organizers for giving us this opportunity to present our joint research. And as Bo has already said, this research emerged from our participation in policy discussions in the SEP space. And to be a little bit more precise, I think it's worthwhile listing some of these widely discussed goals of regulatory action in the SEP space to kind of try to understand how our thinking would apply to these. So one widely discussed goal, obviously, is the idea of creating transparency on what we call SEP exposure, including things such as the identity of potential SEPs and to what extent they are actually essential or even valid. But also encompassing things such as the transparency on unlicensed uses of SEPs at different places in the value chain. In addition, another important goal is the goal of achieving clarity on the FRANA value of individual SEP licenses. So that encompasses at least two things. It encompasses clarity on the legal substance of the FRANA obligation, but also availability and analysis of the information that is required to actually then determine the FRANA value of an individual license. Finally, another equally important goal is the goal of achieving transaction cost savings in the licensing of SEPs, including in the resolution of licensing disputes. And it's very clear that each of these goals is undisputably desirable. I mean, at least in the sense that living in a world in which these things are available for free, we all can agree that we would be better off if there is full transparency, if there is clarity on the FRANA value of SEP licenses, and if we can bring transaction costs in the licensing of SEPs down to zero. But on the other hand, there also is obviously a potentially tremendous cost associated with each of these goals. So if we just think about SEP exposure, which, as I mentioned, has various components, one aspect for which there already is a system in place for providing society with transparency is validity. We already have a system of third-party checks of validity through the patent offices. And if we combine the different costs incurred by the patent office examiners and the parties and with their lawyer fees and so on, we can safely estimate that society has already spent billions on knowing whether these patents are valid. And it's obviously not currently in place a comparable system for essentiality checks, but we can speculate about the cost of what that would be. So one data point that the European Commission study on the essentiality pilot project has brought about is this price tag of patent pools for essentiality checks, which ranges somewhere between 5,000 and 10,000 per patent, which, as the authors acknowledge, is an incomplete or imperfect check in itself. And applying this to the several 100,000 declared SEPs already would also bring the price tag of that to the billions. And obviously, for both validity and essentiality, if we applied the amount of analysis that we see in some individual litigation cases or disputes, then we would have to multiply these figures by 10 or 100. Similarly, for the figuring out the correct FRANA value of an SEP license, I think many of you have participated or have been familiar with at least the ongoing long-standing debate about what does FRANA mean. And clearly, we have already spent significant resources in trying to understand what FRANA means. And so it's we have to evaluate to what extent is every further marginal unit would then add to that. But also, obviously, every guidance on the meaning of FRANA would only go this far in determining the actual value of an individual license. And so there's a big idiosyncratic element to each license, which would then also be costly to resolve unless you create a framework that is plain and easy. An example of a framework that is could be created at very low cost. It's just stipulating that the correct FRANA value of every SEP license is 0. So that is costless, at least in the simplistic way of transaction costs, but it obviously creates potentially significant social costs if the price that we are setting is wrong, because then we are setting wrong innovation incentives and potentially wrong incentives for companies to use this standard in the market. So for each of these things, there is what we have identified as a very significant information problem. It's not that much that there is debate about whether there's value in achieving these goals, but there is tremendous uncertainty in how much investment is socially desirable in the pursuit of each of these goals. And in our reading or our sentiment in participating in these debates is that very often this information problem is ignored away. It's assumed away, or people don't take it as seriously as we have tried to take it. And in our understanding, it is actually the most fundamental, the most central element of a rational economic order. That is that there is information that is needed for the definition of sensible regulatory actions, which is not centrally held, but it is held by a lot of different parties and actors, which each hold like incomplete and frequently contradictory bits and pieces of that information. And so the traditional academic analysis, at least in the traditional analysis as it has been applied to SEPs, is the one of finding and discussing potential market failures and juxtaposing these market failures to a supposed intervention of a social planner or a regulator that presumably knows what the level of investment should be and is therefore in the position to be able to correct the market which sets incorrect incentives. So we try to build on a different stream of research, different literature, which highlights the role of economic governance and thereby provides a conceptual framework in which there's more than just market and social planners. There's a diversity of private and public ordering mechanisms available. And in particular, important private ordering mechanisms that are not fully subsumed under market mechanisms are the rules of private organizations and social norms. And this regulatory framework has important properties. In particular, it elicits information from the different parties. It provides incentives for parties to reveal the information that they possess, rather than presupposing that it exists or that it could be produced through a relatively easy process that we don't need to care about much. And I want to walk through two different examples at a very high level. So it's not going to be very specific about the individual policy measures, just to illustrate our thinking on this information revealing property of the regulatory framework. The first is transparency on the essentiality of potentially standard essential patents. So which is one aspect, one important aspect, not the only one, but one important aspect of this transparency of SEP exposures. And there's a hierarchy of layers of private ordering that intervene in determining how much information on essentiality is revealed. I mean, first there's companies' own incentives to disclose relevant information about their own SEP portfolios. Companies that try to offer licenses to SEP licenses have at least some degree of interest or incentive in providing potential licensees with information about these SEP portfolios, as they want to motivate these parties to get a license for that. There are widely known and well understood potential reasons why these incentives might fall short. For example, by revealing valuable information about my own SEP portfolios, I'm creating incentives for implementers to not only get a license to my own patents, but also to those of my fellow SEP owners. And therefore, I'm not internalizing the full value of my disclosure. That's just one example, of course. And then in order to correct these insufficiencies in first-party private ordering, we can think of potent second-party private ordering mechanisms, in particular when dealing with opportunistic behavior. So companies that have been found to abuse of lack of transparency that they have created through their own action might see repercussions from that behavior. In particular, they might see that it's becoming more difficult for them to collaborate with other companies or to build other types of commercial relationships. An important limitation of that private ordering mechanism is that it kind of presupposes that it's a trust-based environment in which we know in which companies can collaborate with each other because they have been engaging in repeat interaction, which might reduce the extent to which the system is open to newcomers. And there, it's where the third-party private ordering mechanism becomes really important, which is that this interaction takes place in an institutional environment in which, in particular, the standard development organizations themselves define rules and policies requiring certain types and levels of disclosure. So the way we think about this cake of different layers of private ordering mechanisms is that it is really powerful in revealing information and preferences of the different parties about the extent to which an additional unit of disclosure is valuable. First of all, we can see that there is significant and actually meaningful variation between different SDOs' disclosure policies. So there's a large number of different SDOs, and their policies differ significantly in terms of the scope of disclosure that they request, the timing, but also the depth of the required disclosure and the sense of the amount of information that declarants are expected to disclose. And not only is that evidence that there is at least some level of choice for stakeholders in which institutional environment to participate, but also there is evidence of relatively frequent changes to disclosure obligations and declaration policies, which means that if a policy is found to be undesirable by a sufficient group of an SDO stakeholders and decision makers, then it can be changed. So these are two elements where the definition of the rules themselves already reflects parties' preferences, because parties can basically vote with their feet and select an organization with a rule that they like, but they also can directly participate in the governance processes for changing those rules that are found to be inefficient. But then in addition to that, and probably more significantly than that and more directly than that, the rules allow for variety and heterogeneity in companies' disclosure behavior. So almost every major SDO's disclosure policy has at least some elements of a menu. So many important SDOs, for example, offer companies to choose between blanket disclosure and specific disclosure of individual potential SEPs. In other organizations, companies have the choice, but not the obligation, to identify specific standard specifications or even a section of a standard specification to which their declared patents are potentially standard essential. And we actually see that companies make very different choices within these options, within these menus. And in addition to that, very important provisions of the policy are open to different interpretations. So, for example, the timing of disclosure in a timely fashion can be interpreted in many different ways. And obviously, companies make different choices in deciding which patents they wish to declare as potentially essential. How wide a net they want to cast in doing that. But what I think is really telling and really important for us in that is that we see that the majority of declarants actually exceed at least some minimum requirements in at least some respects. So it's not that companies are only disclosing and declaring up to the point where it fulfills their hard obligations, but there's evidence that that private mechanisms are at play because the majority of declarations go beyond what is required in at least some respects. And this is not to say that public ordering has not been important with respect to transparency. I mean, the most explicit and perhaps the most complete disclosure policy is the one that goes back to 1994 at ETSI, which arguably has been strongly influenced by the European Commission's white paper from '92, where not only does the Commission state the value of SEP transparency, but it also underlines that it's actually up to the standards making bodies to establish procedures that would elicit these disclosures. In addition, of course, the policymaker has a role to play as offering a potential enforcement mechanism against behavior that does not comply with parties' obligations. And for example, the statement of objection of the European Commission to REMBUS is an example for where an intervention of the policymaker resulted in commitments by a company and thus changes in the market strategy of at least individual SEP owners in response to a public policymaker's concerns. The fact that this has exceedingly rarely been used as compared to the large number of declarations does not mean that this availability of an enforcement mechanism of last resort is not meaningful. It might just mean that it's very effective, that companies know that this mechanism exists and that therefore the incentives to shirk are ultimately constrained. And finally, there's an option for policymakers to reserve certain benefits to certain SDOs that have disclosure policies that they like. And one example of that is, for example, the safe harbor provisions in the still current horizontal guidelines of the European Commission. So that doesn't define an obligation, but it provides a certain benefit to SDOs that adopt certain policies. But even for that use, which doesn't define obligations, the Commission currently sets a pretty low floor and explicitly extends these benefits, for example, to SDOs that are fine with blanket disclosures. So in addition to these roles, there have been frequent experimentations of policymakers with more direct forms of intervention. So we're listing two particularly telling examples, which I believe are quite informative as they reveal what we think is an important property of this regulatory framework. One is the revision of ETSI's IPR policy in 2005 in the context of concerns about potential patent ambush, where the Commission directly requested to make changes in the IPR policy, presumably in order to make it easier for competition authorities to prove ambush behavior, to prove violations of disclosure obligations, where companies, instead of having the obligation to disclose patents they become aware of, are now obliged to a reasonable endeavor in producing that information. But interestingly, at the same time, this public policy intervention led ETSI to seek and obtain reassurance from the Commission that patent searches are not required. So this provision that could be interpreted as increasing the degree of stringency in the disclosure obligation is almost cancelled out by this, at the same time, inclusion of a reassurance that patent searches are not required. And this reassurance of that the SDO's patent disclosure policies do not involve an obligation of patent searches have actually then been introduced in the policies of a larger number of SDOs. So arguably, the intervention did not at least unambiguously shift the cursor of private SDO's disclosure policies in the direction of greater stringency, but incorporating these private reactions might actually have achieved the opposite. And another telling example is a clause that exists in ETSI's IPR policy, which allows the European Commission to request ETSI to conduct IPR policies, IPR patent searches, and to cover the expense of that search. So when the Commission feels that this is a particular exceptional circumstance in which the value of that disclosure would outweigh the cost, then the Commission has a means to actually pay for that search and request it. And earlier versions of the IPR policy guide of ETSI explicitly acknowledged that this clause has very rarely, and I don't know if it has ever been used. So even though the policymaker actually has as its availability a tool that allows it to substitute its own judgment to the market actor's judgment, how much disclosure should be provided, it actually has very rarely exercised that right. So this is for disclosure policy in very brief. The other important aspect of SEP policy is obviously the clarity on FRAND, the FRAND value of SEP licenses. And I'm going to be a little bit fast on that, in part because so much has been written and said about the relevance and limitations of first and second party private ordering mechanisms. Basically, the entire literature about whether market incentives are enough to regulate the prices of SEPs. And here we can see that there also obviously exists a system of third-party private ordering through SDO policies. But by contrast to what we have seen with disclosure policies, these policies are less directly active in regulating parties' behavior, at least in the sense they are less directly responsible for eliciting relevant information. In part, we see that there's much more limited variation between different SDO policies provisions in that respect. We see that changes in SDO policies in that respect are less frequent, and they come rarely from within, from the SDO community, and even more rarely are they adopted by SDO members' consensus. And there's very limited use of alternative options in commitment menus. So some SDOs offer menus of commitments, including FRAND or royalty-free or non-assertion. In some SDOs, there are options to request reciprocal licensing, but we see that there's much less meaningful variation between companies in their behavior of actually using these options, in the sense that the vast majority of declarants actually just uses a FRAND commitment. And we argue that more directly and more specifically, the goal of clarity on FRAND is achieved through industry norms. So what do we mean by norms? So norms, we believe, are defined by at least two elements. On one hand, it's common practice. So for something to be a norm, it has to be widely practiced and widely shared. And second, there must be some element of, some normative element, in the sense that a practice that is widely shared but widely regarded as unsustainable is not a norm. So there must be some commonly shared value judgment that this is indeed a normative, like a normal sustainable practice. And we clearly see elements of both in FRAND. I think that definitely FRAND is defined by reference to common practice. We see that clearly playing out in the decisions of third parties that are asked to intervene in SEP licensing disputes, where very frequently comparable licenses or other company statements about what they believe is the FRAND value of a certain standard are regarded as relevant. But also there are economic mechanisms which mean that if your licensing offers deviate too much by what your negotiating partners experience as normal practice, you're creating incentives for the other party to challenge your patents, to sue you, or to say it in the other way, like it's if your licensing offer is conforms to industry norms, it's much more likely that your licensing offer is going to be picked up quickly, and so you have an expedient rollout of your licensing program. So that means that there's some element of FRAND which is defined relative to common practice in the industry, and that's an important element. And that goes both ways. I mean, licensees definitely also have an interest to keep royalty payments low, but I think what's more important for many licensees is the incentive of keeping their royalty payments low compared to their competitors. So as long as you don't overpay compared to what other companies in the industry pay, maybe the acceptability of licensing terms is increased. And in addition to being defined by common practice, we believe it is defined by what we call shared value judgments. So there is obviously a large market for FRAND theories. So there's a private market, if you wish, of theories and concepts that are authored by all kinds of different parties. And what's important is that there's an opportunity for buy-in from different parties for each of these theories, each of these concepts. And a theory or a concept that doesn't receive buy-in from relevant stakeholders from at least two sides of the spectrum is not likely to heavily influence the FRAND norm as it's going to be applied both by parties themselves in bilateral negotiations and by third parties in adjudications. And if we look at parties' statements on what they think would be reasonable aggregate royalties for different standards or different standard generations, we often see that these what we may call high-level value judgments about FRAND, they're not that far apart from each other. So it's obviously that doesn't translate into agreement on individual licensing terms in every instance, but it definitely shows that there is a potential for agreement on some core principles that actually goes significantly beyond the interests of individual parties. And so once again, that is a system that is defined by decentral mechanism. And once again, that doesn't mean that the public order is irrelevant in that system. So the public ordering in particular acts obviously as a guarantor and adjudicator. So as a guarantor, that if a party is found to run afoul of its clear obligations, then there might be sanctions available for that under public law. And then, but also the public ordering provides for institutions that might intervene in the determination of whether parties have met their obligations. And what's important for us is that these adjudications might be an important complement, or they might actually be a substitute to the definition of FRAND norms. When they are a complement is when they actually refer to the norms as the source and hold parties to the norms. Whereas when they are a substitute is when they are based on extraneous considerations of what the norm should be. And we see examples of that not only in the adjudication of individual parties' disputes, but also in the influence that public ordering has on the definition of private SDO's policies. So we have we briefly discussed the experience of two different types of influence. One in the already alluded to case of the European Commission's white paper and other activities as they have influenced ETSI's 1994 policy, where importantly the European Commission has emphasized the value of balance in IPR policies as it was in the Commission's view displayed by already existing policies of other private organizations. Whereas in another case, another SDO has made policy changes in a context in which at least some policymakers were advocating for changes to SDO policies based on considerations from academic research or policy analysis about what should SDO policies be, but not based on existing policies and existing experience. So all this might be read as a very conservative interpretation or a framework that is very conservative in the role that it gives to public regulation, but it's not intended to be. We don't advocate that public regulators should sit back and just given the importance of the information problem that we state, shouldn't do anything. But we think that public regulation is best applied specifically to address the information problem. So one easy action in that, and easy in the sense that it's quite consensual, is that obviously the policymaker can produce factual information and analysis, which no individual market actor is sufficiently incentivized to produce. But then there are also a little bit more complex conceptual interventions. One is what we have labeled public entrepreneurship. So when there's uncertainty about the value of a particular action, which ultimately could be an action provided by market actors, there is a plausible argument that market actors are actually insufficiently incentivized to do the risky investment of doing it, of being the first one to do that at least. Because by doing it, if you succeed, you're signaling to the rest of the industry that this is actually a profitable activity, and other people are quickly coming in to dilute your profits. Whereas if you fail, then other people can get access to the information that there is no sufficient demand for what you're doing without having to pay for that. So we can think of the Hantai system of the Japanese patent office as public entrepreneurship, which is basically we're assuming the risk, we're doing this, and we'll see whether what we are offering meets industry demand. And if that's the case, then it's up to like it's in the freedom of private actors to step in and also provide similar services. And finally, we think that even though it's a decentral system in which market actors have ample opportunities for preference signaling, it does not necessarily mean that it's a system as it is that is great in producing experimentation, in the sense that individual SDOs would adopt policy changes with the explicit goal of producing information about whether this policy change is actually helpful. Because at the end of the day, no individual SDO has an incentive to do that. To first of all, to assume all the costs and risks of running the experiment, and if that benefit is then shared by all. But also, once an SDO has adopted the policy, it doesn't have much strong incentives to tell the rest of the industry about all the problems that it is facing. And therefore, we believe that to the extent that public ordering or public regulation does play a role in accompanying rule changes at private SDOs, one important or one potentially beneficial way of exercising that role is by encouraging SDOs to take that value of that external information that they produce into account. So this is our preliminary takeaway from these different discussions that we've had, and we look forward to your questions and comments.
Okay, thank you very much for this great presentation. We are moving to the next slide. Before starting the Q&A, we have received a few questions through the Q&A tool on the lower right of your screen. Please feel free to ask more questions. I would like to just remind you before starting that we have two events, one on the 23rd of November on licensees negotiation groups, what, why, how, and on December the 9th and the 11th, the CIP forum at Gothenburg in Sweden. And the focus of the event is on sharing innovative ideas, research, and practical experiences among global actors. This event is organized by Dr. Bowman Heiden. Okay, so the first question that we have received is, how can public policy for SEPs benefit from a clearer understanding of private and public ordering and their market implications?
Yeah, I can start with that one, Justus. The idea here that you find when you start to discuss these issues about problems or potential, what are the problems sometimes are taken for granted, and what should the solutions be, it's important to go back to first principles and try to understand how the market operates. And are we talking about changes in policy changes on the fundamental level, altering, say, property rights and how they're done or how contracting is done? Or are we talking about operating on the transaction layer? But more importantly, what has already been done? What type of guidance has already been created, and what has been the response? What other regulations have already been used, and what has been the response? And what have private actors themselves done, and how, especially collectively, and how has that worked out? As Justus explained, through these different levels of private ordering, there's a lot of implicit checks and balances. So the things that you think would be a problem are not necessarily something that needs to be regulated, because this is not a problem that would last very long in a collective market structure, because the actors would be able to handle it themselves, which explains why there are a lot of theories about market failure, yet the market is rather successful. And probably many of those can be explained by these different private ordering mechanisms that incentivize people to behave properly most of the time. Justus, you have anything to add?
You're muted.
I was going through the questions in the chat also. I think that the main benefit is to clarify specifically what is underprovided, rather than trying to understand what is valuable. And that's a big difference, because there are many things that we can agree on are valuable, but it's much more difficult, and arguably it's impossible to fully analyze how much we should invest in creating these valuable things, and whether we already are over or under investing. So we need to focus on things that arguably structurally the public regulator is best at producing.
Okay.
And like you said,
thank you.
Like you said, Justus, there's lots of experiments that have already taken place we have to take into account. Please go ahead, Axel.
There is another question in Q&A which says, do you think SEP FRANA rules should be different for operating companies and non-practicing entities?
Sounds like a trick question. It's no, I could start out again, Justus.
Sure, please.
To some extent, everything is a bit different, right? I often describe FRANA as being wonderfully vague. So under a FRANA set of norms, there are no specific rules. In many ways, there's a general framework of how people should interact with one another. So this allows for a lot of different activities to happen underneath the umbrella of this. So private ordering can take place under the governance of FRANA in a relatively open and diverse way, which allows for operating companies to interact with each other and NPEs to operate with operating companies, and they don't all have to they all don't go under the exact same set of specific rules and regulations, but under the umbrella of fair, reasonable, and non-discriminatory. So I would say that they are different because the framework allows for it.
Yeah,
Okay.
I mean, one thing that we say in our paper is that the presence of non-practicing entities in itself is actually under a transaction cost economics kind of framework is interesting, because when we talk about all these different transaction costs, the textbook solution to transaction costs in the literature would be vertical integration. So we would expect that the greater the problems in the SEP licensing are, the greater the frictions are, the more we should see as an endogenous response in the market that actors integrate. So if we see the opposite, that if we actually see an expanding scope of vertical disintegration, that actually speaks to the existence of a market which is actually functioning. And if that's expanding over time, for me that is an indicator that the frictions in the market are actually reducing over time.
Okay. Next question is, as SEP licensing is changing, e.g. because new actors participate, is there a need to reimagine the regulatory framework for SEPs?
Maybe I take the first one on this, Bo, and then you can step
Yeah,
back
go ahead,
up.
Justus.
So I think that this is a common motivation for regulatory policy discussions is to say that, okay, we have a system and many people are actually willing to agree that the system as it is working. But then like we have to be careful because now a lot of things are changing, and we probably would expect that things that are working will no longer work once these changes have happened. And I think what Bo and I have discussed as norms clearly are a function of a certain set of actors in a certain setting. So clearly these are adapted to a system that exists and might not be adapted to a system that changes. But obviously norms are living things. Obviously norms evolve, and we already see that in a way. So we see that some of these conflicts that arise right now are evidence of frictions or clashes of norms, but they are also producers of new norms, and that doesn't mean that that there's no role for the public in that. But I think it's important to understand this evolutionary concept of changing norms rather than just substitute norms as a regulatory tool by something else.
Yeah, I think we have to not try to, in Sweden we say, paint the devil on the wall. If you go back to the Lemley Shapiro paper, they kind of launched this whole idea about patent holdup. Their paper was mostly about issues related to patent assertion entities, and then they extrapolated into standards. But standards are a completely different context. It has a lot of collective activity and a lot of feedback loops. Same thing as we move into new areas like IoT. We're going to move into different contexts. It doesn't mean that more standard essential patents or more actors is necessarily going to be a bigger problem. It just means that you need to be able to understand what mechanisms there can be to manage this situation. It's possible that as you move into new areas, if discussions can be done before markets already start to sell products, new norms can be created and things can go smoother. So sometimes the change in market situations facilitate the change in institutional norms among actors and can make things even easier than it was before. So it's good not to jump to conclusions that there's more patents, there's more standards, everything is going to become more difficult. Not necessarily.
Thank you. I'm afraid that now it's time to conclude, despite the fact that we have a long list of questions. It is 5 o'clock, so I would like to thank you very much, Bowman and Justus, for sharing your knowledge and expertise. I think it has been very useful for the audience and as well as for me. Thank you also to all of you for attending this webinar. Later today, you will receive an email inviting you to complete a 1-minute survey about future topics you would like us to cover. We will be very grateful for your feedback. As explained before, a recording of this presentation will be made available on 4IP Council website tomorrow. Don't forget to register for the upcoming webinar, Licensing Negotiation Groups, What, Why, How, with Harry Stilkas and Igor Nikolic. And should you want to go to the CIP forum in Gothenburg, please check the website and register. So thank you very much to all of you. Again, Bo and Justus, and I wish you all a great end of the day. Thank you.
Thank you.
Thank you, Axel. Thanks, everyone.